Open letter to the Lord Chancellor. Date: 10th August 2025. To the Right Honourable, the Lord Chancellor and Secretary of State for Justice. CC. Lord Lady Chief Justice, Master of the Rolls, Senior President of Tribunals, Justice Committee, Joint Committee on Human Rights, HMCTS Leadership, OHCHR, Treaty Bodies, Media and Civil Society. Subject: Process over justice in England and Wales, your Strasbourg speech, your statutory duties, and the rule of law in practice. Lord Chancellor, your Strasbourg address on the 18th of June 2025 proclaimed that laws are clear and apply to all, power is exercised within limits, and everyone, government included, is bound by the rules. We agree. But the system you oversee is not living up to that standard. Parliament put this beyond doubt in the Constitutional Reform Act 2005. It preserves the constitutional principle of the rule of law and your constitutional role in relation to it, Section 1, and imposes a duty to uphold the continued independence of the judiciary, Section 3, alongside your oath to respect the rule of law and ensure resources for the courts. Courts and HMCTS are public authorities under the Human Rights Act 1998. It is unlawful for a public authority to act incompatibly with convention rights, Section 6, with remedies available where it does, Section 8.
The judiciary's own handbook for litigants in person sets the standard. Access to justice is a right, not a privilege. That promise binds court administration and daily practice. The Supreme Court has repeatedly intervened when executive or administrative action undermines those fundamentals. Unison, 2017, struck down tribunal fees for impeding access to justice. Miller, 2017, and Miller-Cherry, 2019, reaffirmed that power is exercised within limits. Evans, 2015, and Privacy International, 2019, police executive overreach and attempts to oust judicial scrutiny. Those are the guardrails for any clarification of rights you trail domestically.
New CPS NFA. Prosecution inconsistency. A direct clash with your Strasbourg test. You said rights must align with common sense, fairness, and responsibility. Applying your test, the following inconsistency collapses public trust. What the record shows. The police CPS case, history shows prolonged returns to action plan, then charges authorized and recorded as date charged. 19 July 2023, URN 01CW/14388/23. Subsequent entries, evidence ongoing prosecution activity into 2025, fresh exhibits, translations, disclosure. The same bundle records the iterative CPS case returned. Further action plans cycle across 2022 to 2023, followed by resubmission and charge. That is clear on the CRISCOPA log. Separately, a recorded call transcript asserts that an NFA, no further action, had been communicated before prosecution steps resumed. If an NFA was in fact made, the CPS can only lawfully reverse it by complying with its own reconsidering a prosecution decision policy, exceptionality, reasoned review, and proper recording. We have not been provided with that reconsideration record. Why this matters in law and under your speech, CPS policy binds CPS. The Code for Crown Prosecutors requires continuous application of the evidential and public interest tests, with decision-making that is fair, reasoned, and recorded. Where earlier decisions, including NFA, are reconsidered, CPS guidance requires lawful basis, documentation, and transparency. Proceeding after an NFA without the mandated reconsideration process engages abuse of process principles and undermines legitimate expectation and fairness. Rule of law alignment. Your speech insists that everyone, government included, is bound by the rules. Proceeding to prosecution after an NFA without the CPS's formal reconsideration pathway is the very antithesis of that claim. It is not clarification, it is erosion. Access to justice and fair process. The unison principle condemns administrative obstacles that effectively deprive individuals of fair adjudication. A ping-pong of opaque CPS decisions, First NFA, if made, then prosecution without a reasoned disclosed reversal, substitutes process gamesmanship for justice. That corrodes Article 6 and public confidence. Our requests, targeted, lawful, measurable. A. Immediate disclosure by CPS, 14 days. Produce the NFA decision record, date, authorizing lawyer, rationale, and the reconsideration file. Who reopened, on what new evidence or public interest basis, and when. Produce the CPS code and reconsidering policy compliance notes for this case. B. Targeted pause and guidance, system-wide. A temporary moratorium on strikeouts of pleaded human rights claims unless orders explicitly engage Article 6 and proportionality with reasons. Joint guidance with the senior judiciary that no case-ending order or late prosecutorial reversal proceeds without recorded rights analysis and disclosure of the decision pathway, including any NFA to prosecution reconsideration. C. Independent audit and publication, 24 months data. I. Strikeouts. T. Civil restraint orders. T. Failures to provide adjustments and fair process to self-represented charged vulnerable users. IV. CPS reconsiderations post-NFA. Publish findings with corrective actions and timelines. D. Access to justice compliance check. Benchmark HMCTS practice against the Handbook for Litigants in Person Commitments and report to Parliament on implementation. E. Training and resourcing. Refresher training for HMCTS, CPS, Judicial College on HRA, S6 duties, proportionality, abuse of process, and the CPS reconsideration framework. International accountability. This situation has been referred under the United Nations Convention on the Rights of Persons with Disabilities. While the UK is dualist, your Convention on the Rights of the Child 2005 duties, rule of law, judicial independence, resourcing, require you to ensure domestic administration does not place the UK in continuing conflict with its international human rights obligations. Next steps. Please respond within 21 days with 1. The CPS disclosure above. 2. Your plan for a targeted pause. 3. Timelines for guidance and audit. And 4. The mechanism for reporting to Parliament. Your own Strasbourg standard, everyone is bound by the rules, must now be delivered at home. Yours faithfully, Civil Rogue Movement Limited. On behalf of affected court users and the public.